Men busted for trying to solicit sex from kids online. If found guilty, they could get 10 years behind bars. But that doesn't mean they'll actually do the time.
It is subject to parole after 2.5 years. That does not make any sense to us.
The Attorney General is working to abolish parole for all crimes in our state. Currently in South Carolina, convicted child molesters, people found guilty of beating their spouses, abusing or neglecting old folks, prostituting their children, even people convicted of great bodily injury on a child could get out of jail after serving a quarter of their sentence or less. The Attorney General says it's ultimately up to a parole board.
When a judge imposes, for example, a 10-year sentence, and then it does not mean what the judge says, and it's not the responsibility of the judge. It's not the fault of the judge. He can't do anything about it.
McMaster wants to leave the sentencing up to the judge.
He, not a parole board, is the one we believe that ought to make that decision.
So what does the Department of Corrections think about the AG's plan? In a statement, Director John Osment says that his administration is not opposed to any idea that would make our criminal justice system more effective. But he says we'll need more money for prisons because, quote, in any state that abolishes parole, the inmate population will grow. South Carolina is no different. McMaster says that isn't true. He says when Virginia abolished parole in 1994, the number of inmates went down. McMaster thinks if criminals know they'll actually have to serve a hefty sentence, it will act as a deterrent.
They know that they can't outlawyer the system, when they can't manipulate the system, that the sentence means what it says, then you have a